Hello and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I'm Andrew Moyle, Data and Technology Transactions Partner based in London. Well, I don't need to tell anyone listening to this that 2020 has been a tumultuous year. The effects of COVID-19 are ongoing, and many companies have found themselves in financial distress. So in this episode, we're considering the impact of the new Corporate Insolvency and Governance Act, which became law on 25 June 2020, as well as existing insolvency-related regimes in the UK and the US on commercial contracts, where one or both parties to the commercial contract is in financial difficulty. I'm excited to be joined today by my fellow Latham partners from our Restructuring and Special Situations team, Jessica Walker in London and Adam Goldberg in New York. Now, the Corporate Insolvency and Governance Act is intended to help companies maximise their chances of survival to support the UK's economic recovery. Of key significance to parties who have entered into commercial contracts for the ongoing delivery of goods or services is the treatment of Ipso Facto clauses, which historically allowed parties to terminate commercial contracts on the grounds of insolvency. This is particularly important as companies have come to increasingly depend on third-party service providers for critical business functions. Jessica, if I could turn to you first, could you please give us a quick introduction to the UK's Corporate Insolvency and Governance Act, and let's just call it the Act going forward here, and just let us know when the Act was first introduced and what was the rationale behind it.
Yes, certainly. The Act was first introduced as a bill in late May this year, following an announcement made by the government just before Easter, and it was intended to provide assistance for companies facing distress as a result of COVID-19. Now, some of the measures introduced by the Act provide a temporary breathing space for companies to help them avoid insolvency that might result from COVID-19. For example, companies are protected from most threats of being wound up if the company's inability to pay its debts was caused by coronavirus. And directors also are protected from incurring liability for wrongful trading until the 30th of September 2020. And the government might extend that protection up to the end of March next year if needed, if the coronavirus situation continues. But the Act has also introduced a few processes that have been under contemplation for some time, and they're being introduced now to help companies facing insolvency as a result of the COVID lockdown. The first of these is a new moratorium, which gives a company a period of protection against creditor action to enable it to put together a rescue or restructuring. Some companies are excluded from this, though, including financial service companies such as banks, insurance companies, investment firms, and also any company that is party to a capital market arrangement involving debts of over £10 million. So any company that's issued bonds won't be able to benefit from the moratorium. The second of the processes that was introduced is a restructuring plan, which is very similar to the English law scheme of arrangement, with a few changes, not least of which is that it offers cross-class cram-down, so that if a class of creditors votes down a restructuring proposal, they can't prevent it proceeding if they would not be worse off under the restructuring than they would be in the most likely outcome.
So Jessica, as I mentioned at the start, and thank you for that, the impact of this new Act on commercial contracts, and what's new here is that the Act also addresses ipso facto clauses in commercial contracts. It's not often one gets to talk Latin these days, so what are ipso facto clauses, and what does the Act say about those clauses?
Yeah, an ipso facto clause is essentially a provision in an agreement that allows a party to terminate due to the other's insolvency.
Right, so essentially ipso facto translates to by that very fact. So the agreement would include a provision that allows, by that very fact, of one party going into insolvency for the other party to terminate the agreement. And these ipso facto provisions are certainly very common in commercial contracts.
Exactly, they are in most contracts. But under the Act, any contracts for supplies of goods or services that contain these clauses, those clauses will be unenforceable when the other party enters into an insolvency process. So, for example, suppliers will no longer be able to hold a customer to ransom when it enters insolvency by threatening to terminate, or as well demanding payment of arrears or imposing onerous terms, unless the insolvent company, the insolvency appointee, or the court agrees. The supplier will be able to terminate on other grounds, so for example if there's been a non-payment, but if an insolvent company keeps paying and complying with its obligations under a contract, the supplier has to keep supplying and is not entitled to demand a personal guarantee from the administrator or liquidator. Now, there is a previous rule under the Insolvency Act that covered other contracts that couldn't be terminated on insolvency, but it was a much shorter list of suppliers, and they were forced to continue to trade with an insolvent company, but they have the benefit of a personal guarantee from the administrator or liquidator.
Okay, and say also from a supplier's perspective, customers cannot use the insolvency event as an excuse to terminate their relationship with the supplier, provided that the supplier is still able to meet its obligations to supply goods or services in accordance with its contract with the customer.
Yeah, exactly. And the new rules are in addition to the existing rules that provide that a limited list of essential supplies, as I was saying, such as water, electricity, gas, telecoms, may not be terminated on insolvency or demand payment of arrears in order to continue supply. Though those suppliers may require a personal guarantee, that's not available under these new rules.
Okay. And Jessica, are there any carve-outs from these new rules in the UK Act regarding ipso facto clauses?
Yep, there are two main categories of carve-out. Firstly, there's a really wide carve-out for businesses in the financial services sector, whether they're customer or supplier under the contract. So financial services firms, including banks, insurance companies, payment providers, they'll still be able to exercise termination rights under any contract where another party to that contract enters into an insolvency process. In addition, a wide range of finance-related contracts are exempted, including loans, securities agreements, set-off and netting arrangements, financial collateral arrangements, derivatives and swaps. So parties can be comforted by the fact that they will not be required to provide funding to companies in insolvency processes. Secondly, there's a temporary carve-out for small businesses, which are those that meet two of three conditions, i.e. that they've got to have a turnover of less than £10.2 million, a balance sheet of less than £5.1 million, and fewer than 50 employees. But this carve-out is only until the 30th of September 2020.
Okay, so and what do businesses in the financial services sector need to worry about then if the new laws don't apply to them?
I think the exclusion for financial services firms is actually a benefit because there'll be no restriction on their ability to terminate contracts or impose due terms when a counterparty enters insolvency. So it leaves them with the flexibility to manage their business relationships as they wish. However, those financial services firms won't be able to take advantage of the new moratorium. So there's still no basis for them to have a period of protection from creditor action in order to effect a rescue or a restructuring. So while for many businesses in the financial services sector, such as banks, this will not come as a surprise. But the exclusion reaches much further than that and includes any entity that has guaranteed borrowings. So a number of other companies within the financial services sector are likely to be prevented from using the moratorium, perhaps more surprisingly.
I think it's also interesting that suppliers to financial services firms will also take the benefit of this exclusion in circumstances where they're entering into an insolvency process. And I think that sets the basis for some very interesting discussions between the parties where the financial services customer may be heavily dependent on the supplier to ensure continuity of an important service, and there are concerns about that supplier's ongoing viability to provide that service. And that's something that we're going to focus on in a lot more detail in the second episode on this topic. So, Jessica, is there anything else worth mentioning that our audience may wish to know?
One thing is that perhaps one of the notable things about the Act is what it doesn't cover. DIP financing, which is debtor in possession financing, which is effectively financing that a company can obtain when it's in distress that attracts super priority in an insolvency process. And that was part of the same consultation process as the new moratorium and restructuring process. But it wasn't included in this legislation. And that's despite many people within the restructuring industry believing that having the ability to raise this DIP financing, as is possible under a Chapter 11 proceeding in the US, could be hugely beneficial for a company going through a restructuring or rescue. So we were surprised not to see that.
Right. Well, thank you, Jessica. And that's a really nice segue to Adam. Turning to you, Adam, there's obviously been quite a bit of commentary out there that the new UK Act introduces a regime similar to that found in Chapter 11 of the US Bankruptcy Code. But before we discuss that comparison in a bit more detail, I was wondering if you could just outline for us at a high level what Chapter 11 is in the context of U.S. insolvency law.
Thank you, Andrew. Chapter 11 refers to the chapter of the U.S. Bankruptcy Code that sets out the statutory procedure for reorganization proceedings under U.S. bankruptcy law. Broadly speaking, a debtor that has property in the United States can file a petition to commence Chapter 11 proceedings voluntarily at will at any time. The debtor does not have to be insolvent, but merely needs a good faith desire to restructure its obligations and the approval of its board or otherwise in accordance with its organizational documents. The key elements of a Chapter 11 case include a debtor in possession model that provides the debtor with a great deal of leadership over the restructuring, of course, subject to court oversight. It includes an automatic stay on action against the debtor and its assets globally, a right for the debtor to assume or reject executory contracts. It includes the unenforceability of Ipso Facto clauses, generally speaking. It includes the ability to incur priming DIP financing, as Jessica mentioned, the UK insolvency law does not include. It includes the ability to sell assets free and clear of all claims and liens. That's the 363 sales you may have heard about. And it includes the ability to cram down non-consenting classes under a Chapter 11 plan, or what you may refer to as cross-class cram down.
Okay, and I think probably there'll be quite a few listeners on this webcast who are wondering, why is Chapter 11 relevant to businesses based in the UK or Europe?
Well, really the scope of a Chapter 11 is very broad. As I mentioned, to be eligible to file for Chapter 11, the Bankruptcy Code really just requires property in the United States. It's a very relaxed standard, and it's typically very easy to meet. For example, courts regularly find that even de minimis property located in the United States, such as a bank account or even a retainer paid to a U.S. law firm for the purposes of handling a bankruptcy proceeding, can be sufficient to establish Chapter 11 eligibility. There really is no formal barrier to filing for Chapter 11. And so a UK or European entity could file for Chapter 11 based on a bank account, and it could use the long-arm jurisdiction of U.S. courts to bind any counterparties around the world who may be subject to U.S. jurisdiction. In recent years, some of the examples of large cross-border Chapter 11 cases include the CHC Group, McDermott International, Abengoa, and most recently, since the COVID pandemic, we've seen 3 airlines based in Latin America file for Chapter 11 protection, including Avianca, LATAM Airlines, and Aeromexico. So with the number of English and European companies that have accessed U.S. capital markets in recent years, both companies and creditors based in Europe should be very conscious that Chapter 11 is an option, regardless of where the majority of the company's assets or operations may be.
Okay, so I mentioned earlier that there seems to be quite a bit of commentary comparing the new UK Act with the Chapter 11 regime. Does the UK Act bring us any closer to Chapter 11 regarding these issues? Like, are there any parallels with Chapter 11 based on what we've already discussed?
Yeah, while it might look as though the new insolvency processes introduced by the Act bring us more in line with Chapter 11, there are still distinct differences. As I mentioned before, and as Adam mentioned as well, we don't have the ability to raise DIP financing in the UK, which is key. In addition to that, a company in a moratorium or a restructuring process under the Act can't choose to reject burdensome contracts unilaterally. And similarly, the court doesn't oversee the implementation of the restructuring to the same extent as it does under Chapter 11, albeit that we have insolvency appointees who take on that overseeing role.
And so I think from my perspective, the ability to assume and reject contracts is really key to the operational benefits of Chapter 11. And so, for example, in the context of numerous reorganizations, the retail reorganizations that are happening right now, one of the ways that a Chapter 11 can create value is by allowing the debtor to renegotiate leases under threat of rejection of unnecessary leases. And that provides a tremendous amount of leverage for the debtor against lessors, and it allows a buyer as well to take the assignment of assumed leases in a way that can be very favorable and create a significant amount of value for a transaction. I'd also highlight there's a wide range of more specific provisions around assumption and rejection that have evolved over many years of practice under U.S. bankruptcy law and court, including various Supreme Court decisions and legislative responses. And of particular relevance to this discussion in this audience, I'd note Section 365N of the Bankruptcy Code provides special rights for licensees of intellectual property to continue to use intellectual property subject to the terms of their license, including payments, of course. In other words, although a debtor can usually reject executory contracts, the Bankruptcy Code provides more protection for licensees and allows them to continue to use intellectual property if they elect to continue their license.
Yeah, there are certainly similarities between the two, and the restructuring plan borrows from Chapter 11 in its ability to cram down dissenting creditors. So we're certainly a little bit more aligned in that regard, but there would be more needed to be done to these and other insolvency processes in the UK for them to link up.
I'd like to thank Jessica and Adam very much for the lightning tour of the new UK Corporate Insolvency and Governance Act and Chapter 11 in relation to commercial contracts. Armed with that background, I'm really looking forward to discussing the practical application of these regimes with respect to commercial contracts in more detail in our upcoming second and third episodes on this topic. And in our second episode, we are going to consider these developments from a contracting party perspective. That is, how you can protect key supplier arrangements in the event of financial distress. And then in our third episode, we will consider these developments from an M&A and restructuring perspective. And here we're going to be looking at what to consider in relation to commercial contracts in the context of purchasing or selling a business that may be in financial distress as a going concern. And on that note, thank you and goodbye.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 885 3rd Avenue, New York, New York, 10022-4834. Phone number 1-212-906-1200. 00.